Hey, everybody, it's Craig Valine here, and welcome to the Can I Patent It podcast designed to help inventors and entrepreneurs safely and more easily get their patent or trademark done correctly and save time, money, and effort in the process. My co host today is Dan Kimbell, a 30-year IP attorney. Dan, for credibility's sake, would you just explain some of your background as an IP attorney?
Sure, Craig. Nice to be here today. Like Craig said, I've been an IP attorney for more than 30 years. In that time, I've prepared and filed and prosecuted more than 1,000 patents and many more thousand trademark applications. I've also co-founded several companies. So I have a lot of skin in the game, and I understand a lot of the issues that are faced by inventors with limited budgets, never enough time, too much to do, but they want to succeed. So, I've been there and done it myself as well as advise clients.
Yeah. So, you have a great history. You've dealt with probably experienced inventors and entrepreneurs and new inventors and entrepreneurs.
That's right. That's right. And I've seen a lot of things when they go wrong, as well as when they go right. So I prefer it when things go right. And I think at this point in my career, I can really tell people what they should do and what they shouldn't do if they want to increase their chances of success.
Well, I have some questions for you today, and they might be a little simple or basic, but imagine an entrepreneur who's invented something or has an idea for something. Describe what a patent is and what does it protect?
Sure. A patent application, or a patent when it issues, is a legal document. It's actually a monopoly issued by the government, either the US or if it's a foreign country, that foreign country. It gives you a right to exclude others from making, using, importing, or distributing whatever's covered by the patent. It could be a product or it could be a process. So if you have let's say, a new design for a tool holder, that's a product. If it's let's say, a method of doing something, a method of manufacturing some product, that's a process. Either way, the patent, gives you a right to exclude others from doing that. It's not necessarily the right to do it yourself, but it gives you the right to exclude somebody. So you could sue for infringement if someone infringes.
So you just named a few, but what can be patented?
Sure. Well, any kind of new and unobvious device or product or process.
Okay. So what are the different types of patents that are out there right now?
There are three basic types of patents. The first is called a utility patent. That is a patent on a product or process. The next kind of patent is called a design patent. So if you have a unique ornamental design, not functional, but ornamental, like a new kind of lamp or a wristwatch that looks really nice, and it's just the ornamentation, that's a design patent. There's also a plant patent. So if you have a unique kind of rose bush or some kind of fruit or vegetable, you can actually patent that. Sometimes if you go to a nursery, you see on a rose, you'll see a sign, a tag that says patented roses. That's referring to plant patent. It's kind of weird. I've never actually done one, but certain people do them in the nursery business. And there's another kind of patent. It's called a provisional patent application. A provisional patent application establishes a filing date. It's a full disclosure of the invention, but it never issues itself, but it provides a priority document that kind of tells the world what your patent is. Again, it's not published. It remains secret until a patent is filed and issued. So those are the kinds of patents.
How long does the patent process take?
Generally, it takes at least a couple of years. If it's a utility patent, designs are a little quicker. A couple of years, you prepare the application, you file it with the patent office, and you wait, and you wait, and you wait. If you're lucky, it gets picked up quickly, but like I said, it can take some time. There's actually a process to accelerate the prosecution. It's called Track 1 Accelerated Prosecution. That process, you pay a fee, generally $1,000 for a small entity. That means if you're a small inventor, you pay a smaller fee. And then they will guarantee that you'll get either a final rejection or issuance, notice of issuance within 1 year. So that's really attractive. There's a lot of advantages to doing that. So I recommend anybody who wants to get a patent quickly and less fuss and muss to do that process.
Awesome. What are some of the costs involved in filing a patent?
Patent application process, it really depends on how much you do. You've probably been in a car repair shop where they have a sign that says, if you watch, it costs $50 an hour. If you help, it costs $150 an hour. It's the opposite for a patent process. If you help write the application and if you do a good job writing it up, it helps us a lot. So, but anyways, you can generally look at it anywhere between $5,000 and maybe $15,000 to prepare a good, solid patent application. It's all custom written. It depends on how complicated the invention is and how much work is required. So again, like usually between $5,000 and $15,000. It can be more, it can be less. For design patent applications, it's much less. Usually a couple $3,000 to do that, including filing fees.
So this wasn't on my list, but I was thinking about it. If someone was exploring filing a patent before they do that, are there costs involved there that can be saved by possibly working with a patent attorney like yourself, or an expert, in the process?
Yeah, absolutely. So if somebody's exploring the process, it's advisable to do some patent searching in advance. Now, you can do a lot, the inventor can do a lot of that work, him or herself, by doing searching, and there's some resources that are free. For example, the US Patent and Trademark Office has a website, and they have some search tools. It's kind of rudimentary. It's just kind of keyword searching and used Boolean operators. There's also the European Patent Office has one, and then what's called the International Patent Office. It's WIPO. There'll be some links above that list those URLs, but an inventor can do that and help. That would be a first step. I always recommend that the inventor, if they have time, do a little searching in advance. Sometimes they'll find the same exact thing they've invented, or maybe something that's close, and they may decide it's not worth pursuing it. But after that point, we always recommend professional patent searching done by professional patent searchers. So we work with a lot of search firms, and we provide the search parameters, and then the searcher will generate the results. We review the results and give an opinion that gives the inventor some good advice on the likelihood that they can get a patent of a particular scope. So if you could get a patent, but the scope is this narrow, you may not want to pursue it. But if it turns out that your patent is really unique and compelling, then it's probably worth filing for.
Awesome. Can a patent be challenged or revoked?
Yes, there's patent litigation is something I've been involved with quite a bit over the years. A patent application is assumed valid unless challenged and invalidated. So increasingly, when somebody obtains a valuable patent that somebody wants to copy, they will challenge it. And there's two ways to challenge it, basically. One's called an IPR, an inter-party review process. And that's a process by which a potential infringer will basically request that the patent office re-examine the patent and see if it should be invalidated or narrowed. Another process is directly challenging it through the court system. And then that involves patent litigation. It can be very, very expensive. The typical process to go through full-blown patent litigation can cost $1 to $2 and more million. It really depends on how valuable it is. The general rule of thumb is if the patent's really valuable, somebody will try to copy you, and if they want to challenge it, they may bring a lawsuit. But that kind of tells you if it's really valuable, they'll probably be challenged.
Right. How can someone enforce their patent rights?
Well, they have to use the court system or the threat of the court system. So if somebody has a patent and it's being infringed, usually the patent attorney will write a cease and desist letter to the infringer, trying to convince them they really shouldn't continue to infringe. Many times things are resolved by a simple cease and desist letter, and it doesn't have to cost a lot. And usually what happens is after sending a cease and desist letter, if the infringer decides it's better not to pursue it, then a settlement agreement is prepared. That's the process usually.
Awesome. Can a patent be licensed or sold?
Oh, absolutely. That's one of the values of patents, that it is a property right, and just like other property rights, it can be sold, it can be assigned, it can be licensed. And licensing is wide open. You can do a narrow license for a particular use or market. There's international licensing, there's local licensing. It's really anything you want, you can do with licensing. So it's very, very attractive. In fact, that's one of the major attractions of getting a patent, that you create a property right. So if you have a company and you have more patents, that makes your company more valuable because you have a property right that can be licensed and sold along. If you have a business, you can sell the patent rights.
Awesome. And the last question for today is, what are some of the common mistakes to avoid when filing a patent?
Yeah, I think a major mistake when filing a patent is that people don't do good searching. So they don't know what's out there, and you're flying blind if you don't know what's out there. So either you file patent that's too narrow, in which case you leave something on the table, or you file something that's too broad, that's maybe claims something that's already known, so you get rejected. So you have problems during the patent prosecution process. So searching is very critical to avoid that. Even if you do search, you may have problems, but searching certainly helps avoid a lot of these problems. Another problem I find, especially with beginning inventors, is they haven't really assessed the commercial value of the patent. So, a lot of things can be patented. It has to be new and unobvious. The fact that something can be patented doesn't mean it should be patented, because if you don't have a business case for that invention, you really shouldn't be spending money on preparing and filing patents. Remember, this is not a hobby. You want to patent things that will make you money. If it doesn't make you money, or it doesn't have a good prospect of making you money, you should just move on and do something better with your money.
I lied. I have one more question since it ties into this one.
Sure.
I know you're opinionated about inventor promotion companies.
Very much so. Very much so.
Tell me more about that. Why not?
Well, invention promotion companies are kind of bad. You've probably seen them if you watch late night TV or get internet ads. Some of these companies have a picture of a caveman carving or chiseling a wheel. I won't name names, but
I just saw it last night.
Yeah, you know what I'm talking about. And they have high pressure salespeople. If you call or contact them, they'll get right back to you and convince you that anything you've come up with is patentable, and that you should move forward and sign a check or give them your credit card number, and they'll get you a great patent and they'll promote it. The fact is, they don't really have much of a track record. In fact, one company I recently investigated, of their many representations, less than 0.6% of them resulted in any kind of licensing. And the licensing, the disclosure said that those 0.6% of clients made revenue that was at least as much as the cost of the representation to the promotion company. So that's pretty bad. Yeah. And if you look at the products, I actually looked at them and tried to find them, and most of them I couldn't find. So maybe they were on the market briefly, but they're not on the market now. So your track record is awful, and your money would be much better spent doing good patent searching and doing the market studies to see if you actually have a chance.
Yeah, so that comes to kind of why we're doing this podcast is you've identified some areas of some problems that people have when filing for a patent and some opportunities. And before retaining an attorney or yourself, you've come up with a little offer for people to kind of meet and do so. Can you describe what that is?
Sure, sure. So again, what I found that is a lot of people file, they come to me and they want to file a patent on their invention. And I always ask them, have you done any kind of market surveys? Do you have a business case for this? And sometimes they say, many times they say, no, we haven't. So I usually tell them, before you spend money on patents, you should see if there's a business case for it. And assuming there is, then we can move forward by searching and then deciding what kind of patent should be filed and what kind of claims you want. Because again, if you can get a patent on pretty much anything, but is it worthwhile or not? That's the $1 million question for you. And I can help you with that because I've done this many, many times. Like I said, I've started companies and I've used IP, patents and trademarks and copyrights to help make the company more valuable, protect the company. So I pretty much know what needs to be done. I also have a large network of people I work with, designers, business people, marketing people who can help inventors decide whether they should pursue their invention and to make it successful. So before you spend money on patents, you need to know is it worthwhile, and then what steps you need to take to increase your chance of success.
Yeah, and there'll be a link underneath the description of this podcast with a link to schedule time with Daniel. And you have a $400 kind of commitment charge just kind of for your time and for your experience and everything. But you'll save a lot of time, money, and effort in the process by meeting with Daniel before.
Yeah, I think personally, it's money well spent because if you file an application, you're going to spend many thousands of dollars. And I will probably tell at least half the people they shouldn't pursue the invention for various reasons. So again, not spending the money, spending $400 may help you avoid spending many thousands, and
Right.
certainly will convince you not to go to one of those invention submission companies, which I really hate. Quite frankly, I hate them. I've seen many clients come to me with patents written by these invention submission companies. They don't actually write them. They hire, I think, attorneys who are beginners or don't spend much time, and they're very poor quality, and they don't do anything. So don't waste your money with those people. I have no reason to tell you to pursue a patent. My goal is to help you take the right decision, make the right decision, and then help you find resources to make your invention successful. That's what I want to do. And I think I can help you a lot.
Awesome. Awesome. Well, that's all the time we have for this particular podcast. This has been the Can I Patent It podcast for inventors and entrepreneurs. So we'll see you next time. Thank you, Daniel, for being here today.
See you again. Bye-bye.
Yeah, we'll see you on the next episode. Thanks.
Bye-bye.